did they catch her there? And if they did catch her there, would that affect their ability to fairly deliberate upon the evidence of the case? Because her attending the Oscars has nothing to do with the trial in the case. So yeah, I think it's definitely got to come up. They've got to screen out those jurors who are affected by it and boot them off the jury, as a matter of fact, and seat somebody else.
As we are back now for the third and final hour of America's Forum, we welcome you in alongside Miranda Kahn, J.D. Hayworth, and yesterday on this program, Jeffrey Nathan, you heard right there, the criminal defense attorney from Boston, discussing whether or not the appearance of Taya Kyle, the widow of the American sniper Chris Kyle, at the Oscars ceremony would influence the jury of Eddie Ray Routh, accused of killing both Kyle and Chad Littlefield.
Well, after icy roads in Texas delayed the trial on Monday, the prosecution is set to resume its battle to disprove Routh's insanity plea today. For
today's legal brief, let's call on the noted defense attorney, F. Lee Bailey, who joins us via phone. Mr. Bailey is also the author of the book, Excellence in Cross-Examination. And if it looks like a textbook, it is. So, Counselor, welcome back to America's Forum. Give us your textbook reply to the American Sniper case and Taya Kyle showing up at the Oscars. Do you envision some jurors perhaps being relieved and other jurors coming in this case?
I don't really think it'll have any effect. This is a case about insanity, not a whodunit, and I can't imagine that a juror noting the widow at the Oscars would change his vote, and that's the real concern.
A forensic psychiatrist for the prosecution says that Routh was actually intoxicated at the time of the murder. So would his intoxication mean anything for an insanity plea?
Well, there are two kinds of intoxication. Voluntary intoxication is not a defense, even though it may drive you bananas. Involuntary intoxication in most states is a defense if you can show that you've ingested the toxic substance, whatever it was, without your knowledge or intent.
And mindful of that, Counselor, the fact that any of these disputes bring up a couple of different points of view, we have a portion of a report from CNN's Ed Lavandera from last night. Let's listen and get your reaction.
The prosecution has had two of its own psychiatric medical experts, and what they have told the jury is just the complete opposite. In fact, at some point raising the issue that perhaps Eddie Ray Routh is faking a lot of these symptoms.
And there's more to this, Counselor. Witnesses for the prosecution also said that Routh may have gotten his rants from watching an episode of Seinfeld. So I guess they're going to claim that Routh could be faking mental issues and mental illness. Is that a reasonable charge? Do you think that'll hold sway with the jury?
Well, unfortunately, the sloppiest cases in our litigation system are insanity pleas. It seems inevitable that both sides will find a very enthusiastic psychiatric expert, one of whom is perfectly sure that this guy was beyond control, couldn't help himself, and the other will say anything from faking to Seinfeld, which is a pretty big stretch. If Seinfeld is an inspiration for homicide, we've been very lucky that a whole raft of them haven't already happened.
In your experience, how difficult is it to prove that you were insane?
It's one of the most difficult defenses in criminal law because jurors are being asked to let this guy go, even though it's plain that he committed a vicious and maybe vile act. The best example is John Hinckley, who shot the president. A jury concluded that he wasn't all in one piece. However, in the federal system, the prosecution has the burden of proof. In most states, as in this case, the defense has the burden of proof, and that can make a big difference.
And Texas law and the standards of Texas, we understand, could make it doubly tough on the defense. In about 20 seconds, your knowledge of Texas law and how this case would be received by the jury.
Well, I think Texas standards for judging insanity remain fairly primitive. But that being said, that's true in a lot of states. It's simply a circumstance that we have trouble dealing with defining, and tragically, we have no means and make no effort to treat those who are really afflicted.
Counselor, we appreciate that. We're going to ask you to stand by. We'll bring you back following the break. Meantime, if you want to read the story of Chris Kyle, the most lethal sniper in U.S. history, go to newsmax.com/sniper. Welcome back to America's Forum. Long ago, and I guess far away, there was this slogan in advertising: long distance is the next best thing to being there. Well, with modern technology, we got something even better. Skype is sensational, so you can talk and see the person to whom you are speaking. And in this case, it is noted defense attorney F. Lee Bailey, who now joins us via Skype from the great state of Maine. Counselor, as always, we appreciate your time, and we are going to change venues, so to speak, from the Lone Star State up to a place much closer to you, Boston, where the defense attorneys for Dzhokhar Tsarnaev have been, speaking of changing venues, been unsuccessful yet again in changing the venue of this trial. I'm wondering, Mr. Bailey, do you think the venue should be moved? There should be a change of venue out of the city of Boston for this Tsarnaev brother who remains?
Well, in one sense, there certainly should. In the other sense, what good would it do? This is not a case heated up only by the local press. I'm reminded of a case I had some years ago where a fellow was indicted in Florida for murder 1 week and in New Jersey the next. And I said to the New Jersey judge when that case went first, we have to change the venue because everybody knows he's got another indictment for murder and they'll think lightning doesn't strike twice. He said, Lee, we could take this case to Timbuktu and not win a thing. We'll just pick our jury very carefully. And we did, and he was acquitted.
So you're telling me really in the case of Tsarnaev, change of venue not necessary because it's going to be tough to find a jury who has not heard at least something of the notorious nature of the Boston bombing.
It's one of the two remedies outlined by the Supreme Court in my case, Shepard v. Maxwell. Either postpone the trial, that won't help in this case, or change the venue to a more remote location. And I don't believe that's going to help either. The massive reporting on this case, particularly because of its cruel nature, is going to follow the case even to Timbuktu.
Counselor, jury selection in the Tsarnaev trial began back on January 5th, but was postponed yesterday for reasons that were not reported. But according to the Boston Globe, that jury selection process has resumed today, and the court has indicated the process could conclude sometime this week. Jury selection, especially with a failure to change venue, becomes even more important. If you were conducting the defense for Mr. Tsarnaev, what would go into your questioning to find the, quote, right jurors for this case?
That would depend an awful lot on the defense I intended to present. If it were insanity, I'd want one kind of juror. If it were mistake or I was misled by my brother, I'd want a totally different kind of jurors. It's an individual exercise. Frequently, by experienced counsel, it is tailored to the issues before the bar.
And mindful of that and what you know of the case from reading in the press, this is a unique opportunity. In the 2 minutes that remain, what kind of defense would you try to fashion for this surviving Tsarnaev brother?
Well, I don't know the facts. I have read that a juror commented, well, maybe his brother kind of made him do it. That's not a legal defense. at least not in this case, unless the defendant was at gunpoint. So I am very puzzled with whatever it is that the defense counsel are going to come up with. It's kind of like the Whitey Bulger case. You just sit there and get buried in all probability.
Well, nevertheless, the process continues. And before we part company here, Counselor, I'm interested in the book you put together. We talked about it a while back when you first joined us. But I'm kind of curious in terms of principles in cross-examination and compiling that text. In the minute that remains, was that process a labor of love? Was it maddening? Do you think in the final analysis it's going to help lawyers in the days ahead? About a minute remains.
Well, I think it will help lawyers if they will read it. The Chief Justice of the United States glanced at it and he said, Lee, that looks like a good book, but I don't know if you can sell it. People don't go to trial anymore. And outside of this very prominent criminal case, people don't go to trial very much anymore. So we'll hope it prospers. 20 years ago, I can tell you, it would have been a bestseller out of the box.
Fair enough. Lee Bailey, F. Lee Bailey, as always, we appreciate your time and your thoughts on this. And we look forward to visiting soon again on other cases of note, perhaps even getting a few pointers when it comes to principles of cross-examination. I have to tell you in all sincerity, though, to hear the counselor say people aren't reading anymore, gee, and lawyers are supposed to be pretty good readers. You're watching, and you'll be back to watch more right after this break.